Hello everyone and welcome back to Exam Ignite YouTube channel. This is 5th semester subject Research Methodology and IPR of subject code BRMK557 Module 4 Part 1 video, where we'll be discussing about the copyrights and the related rights. In the Part 2 video, we'll be discussing about the trademarks. So in this topic, the main important questions that you can expect is one thing is the process of registration steps for the copyrights. This is the most expected question in the exam. And then comes the classes of copyrights and the ownership of copyrights, and also copyright infringement in a criminal offense, in a cognizable offense, and also the criteria that original work meet to copyright protection. Then copyright laws, what are the concepts underlying the reproduction of sound recording, is this related to a copyright? Then TRIPS agreement, this comes in the trademark. And also the non-copywriting work, what is the fee structure, then copyright symbol, validity of the copyright in India. Then you can say the copyright and the word adoption, copyrights and the word Indian work, joint authorship means what, copyright society, copyright boards, these are also important, and copyright enforcement advisory council, then international copyright agreements, convention and treaties, and interesting copyright cases. This we will get to these topics now. Coming to the first, we need to define the copyright. So copyright, it is a legal right that is provided by the law to the original creator of the work. So these rights are provided in the field of literature, computer software, and the related rights encompass the author's work in the drama, sound recording, films, paintings, architecture. So this copyright and the related rights are the category of the intellectual property, as we have discussed in the module 3. So in India, this is governed by Copyright Act 1957. The rights protected under the Copyright Act 1957 is: one is reproduction of the work cannot be done without the consent from the author, communication to the masses, and adoption of the work, translation of the work. These are the rights that come under the Act. Meaning of the author and work. Author is the one individual who develops the content of the work. Like writer in the literature work, computer programmer in a software, composer in a music, then producer in the films, photographer in the photographs. Then what is work? Work is a task that is undertaken in the fields of these areas. Coming to the classes of copyright, the second topic here, this exists in the literary works, like includes in the books, essays, research articles, oral speech, lectures, complications, then compilations, then computer programs, software, databases. Then comes the dramatic works, that includes screenplays and dramas. Sound recording means it's about recording the sounds irrespective of the medium, like the CD-ROMs. Then artistic works, that is drawing, paintings, logos, maps, etc. Then musical works, like musical notations, like words included in to be sung. Then spoken or performed actions. So a musical work need to not to be written down to enjoy the copyright protection. Then cinematic films, these are also copyrighted, like TV programs, visual recording, sound recordings. Two exclusive rights of a copyright owner is: one is he enjoys the copyright right to reproduce the work and communicate the work to the public. So criteria for the copyright protection is: one is fixation in the physical form. So the work must be in a physical or tangible form, and the duration of existence may range very short to many years. So any expression that can be viewed or listened to qualifies to this, and even hurried scribbled notes for an impromptu speech are also copyrightable. Then comes originality. So the work must be original, it should be independent thinking and not the duplication of some other's work, and such work is termed as an original work of authorship, OWA. So the work that may appear similar to the existing work but should not be same. So the work may lack quality, quantity, or aesthetic merit, or still qualify for the copyright. Then comes minimum creativity. The work must involve some creative effort of the author. So there is no minimum limitation for the creativity. So it's all about the subject matter, how you express your work. The level of creativity is adjudicated to by the registrator of the copyright to decide whether it is eligible or not. So examples of non-copyrightable is merely changing the dimensions of the book or alphabetically arranged telephone directory. So these things are non-copyrightable works. Next comes the ownership of copyright. So the creator of the work is always the first owner of the copyright. If the author is an employee under the contract, the employer becomes the owner. For the government work, government is the primary owner. For the personal delivery of a speech, the first person delivering the speech, the owner of the copyright. Permissions to use copyrighted material. So you must get a legal grant from the owner to use that work. So legal owner may be the original author or the legal who has hired it or the publisher. So the request must include you are using the title, the author name, edition, exact material that to be used, number of copies you are doing, then purpose, for what purpose, education, research, or what mode of distribution, whether the material is sold or not. So these things to be mentioned in the request. Next comes copyright of the author, copyright infringement in a criminal offense, copyright infringement in a cognizable offense. Explain. This is a model question paper 1 question. So copyright, we know it is a legal right provided to the creator of the work under the Copyright Act 1957. So these rights protects the author's original work from the unauthorized use or misuse. So copyrights of the author, here it is protected under the section 14 of the Copyright Act. The work created by the author cannot be used or published without the consent. So this provides exclusive rights in the publication, distribution, and the usage. So what are the types of rights that is enjoyed by the author? Is we are having two main types: economic rights and the moral rights. So economic rights, these are the associated with the financial benefits. So the owner can authorize or prohibit from the reproduction of the work, distribution of the copies, public performance or communicating to the public, translation of the work into other languages, adaptation of the work. So he can permit or prohibit. Next comes moral rights. So it includes right of paternity. So the author retains the right to claim the authorship. Even if the copyright is licensed or transferred, the author names remains. So example, you can say a author's name in a book published by a publisher. So the publisher is publishing it, the author name should be written in that published book. Right of integrity. Here the author has a right to prevent the misuse of the work. Like this includes prevention of alterations, additions, or deletions. So such changes may harm the honor or reputation of the author who has written, in which context he has written. So a work may be multiple right holders. Example as musical sound recordings involves a lyrics and a composer, singer, and musicians and sound recorders. So based on that, it is having a right of integrity. Copyright infringement. What is this? As per the Act of 1957, Copyright Act, these are the following acts constitute the copyright infringement. One is making the copies for the sale or hire without the permission, selling or letting the infringing copies for hire, then permitting a place for public performance that infringes the copyright, distributing the infringing copies to affect the owner's interest, publicly exhibition of the infringing copies for trade, then importing or infringing copies of infringing copies, then translating a work without the owner's permission. This is what called as copyright infringement. Liability of the owner of an auditorium or hall. The owner of the auditorium or hall is liable for punishable if he knowingly allows his premises to be used for the illegal communication of the copyrighted material. So if the place is permitted for profit for infringing communication, it constitutes an offense. So the owner is exempt only if he was not aware and had no reasonable grounds to believe the infringement would occur. Next comes infringement is a criminal offense. So as per the section 63 of the Act, knowingly infringing the copyright is a criminal offense. So punishable for first offense, it is imprisonment for 6 months and a minimum fine of 50,000. If the punishment is for the second or subsequent offense, if he repeats it again, then the infringement for 1 year and it is a fine of 1 lakh. So there is a dedicated IP division to deal with this copyright cases. A copyright board was constituted by the central government in 1958. Now, copyright infringement is a cognizable offense. So, a public officer of the rank of sub-inspector or higher can seize the infringing material without issuing a warrant, as the seized material is produced before the court of law. Next comes fair use of doctrine. This means it allows the limited use of the copyrighted material without the permission. Like water and all can be used under specific condition as per the section 52 of the Act. So why do we use the part for the teaching and research purpose while balancing the rights of the copyright owner? That is known as the fair use doctrine. There are four part test of that. One is character of use. So it is use must be educational, non-profitable, and personal in nature. Nature of work means it should be used, should be factual rather than imaginary or creative. Amount used, only a small portion of the copyrighted work should be used. This condition is debatable in the current practice. Impact on the value, use should not affect the economic or the moral rights of the author. These are all the four tests that should be considered while using the fair use. Examples like you can use personal use for research or studies, quotations for the copyrighted from the copyrighted work, reporting the current events in the newspapers, magazines, radios or televisions, reproduction by teachers or researchers for academic purpose, pre-performance by government officials during the official duty, judicial use such as reproducing for court proceedings or reports, legislative use for the prepared for the secretariat of the legislature, then certified copies supplied under any law in force. So like this. So next we'll move on to the copyrights and internet. So digitalization era, the 21st century is marked as a digital transmission of the copyright data via the internet. So legal amendments that were made as internet usage has led to amendments in copyright laws. Under the caution, users must follow copyright and fair use of principles while downloading the material. Unauthorized uploads, material on the internet may be uploaded without the author's permission. That is known unauthorized upload. Use of the internet consent. In the copyright owner post material online, users may use it for the personal use only. Commercial use is not permitted without permission. So electronic distribution must include a copyright warning statement, including the educational use or the legal consequences for the infringement. Like if you are distributing it electronically, then also that warning statement should be given with that. Next comes copyright and the computer programs. These are the two sections where it involves and the registration of that. Non-copyrighted works like ideas, concepts, principles are not protected by the copyright. Facts and discoveries like scientific or historical may not be copyrightable. Only the expression of facts and not the facts themselves is protected. So what are the subject matters that can be excluded from the copyright are it does not protect the title, name, slogans, short phrases, short word combination, methods, pure factual information. Certificates are not copyrightable due to lack of creativity. Next comes digital and internet based works. So digitally created works and copyrighted works converted to a digital form are protected. So a website as a whole cannot be registered for copyright. So individual components of the website can be registered separately like your software or database, images, diagrams, maps, like music or notations. These separately they can be done. Mobile apps and software. A computer or a mobile app qualifies for the copyright protection. So an app is self-contained, designed for a specific task, has a dynamic content and allows user interaction. So hence it can be. Online infringement. Using someone else's picture or song or video from the internet without the permission is copyright infringement. The same rule applies both ways. Copying others' work or having your work copied is the online infringement. Next comes copyright registration. Here it is not mandatory to claim the copyright protection. Once a work is created in any medium, it receives an automatic copyright protection. There is no formal request required to acquire the copyright. So registration does not confer rights but acts as a prima facie proof. So the registration certificate serves as the prima facie evidence in the court of law. So what does it help in the disputes related to ownership, creation of work, financial matters, transfer of rights? So hence you can say registration is advisable for a better legal protection. So in India, the copyright matters are governed by the two acts. One is Copyright Act in 1957 and the Copyright Rules in 2013. So let's go to the process of copyright registration step by step. This is important. It has been asked in the model question paper 1, 2, then June, July 2025 also. So step 1 is filing of application. So application is filed along with the prescribed fee either online or offline. Then comes issue of the diary. So after filling, a diary number is issued for your copyright. Then mandatory waiting period. So 30 days of mandatory waiting period is observed. This period allows the filing of objections if there are any. So this objection check, during the waiting period, the author will check whether the objection is filed. If there is no objection, then application is sent for the scrutiny by the examiner and the examiner checks for the discrepancies. If there is no discrepancy, registration is approved. If there is a discrepancy found, then that is letter is issued to the applicant. The reply from the applicant is submitted and then the decision is taken by the registrator. If the objection is filed, then a letter is sent to the applicant and applicant submits the reply. Hearing by the registrator is conducted and the registrator takes the final decision. What if that decision is satisfied or not? If that is satisfied, then the registration is approved. Extracts from the registrator is sent to applicant. If it is not, then the application is rejected, then the rejected letter is sent to the applicant. Benefits of this registration is it strengthens the author's position like the court disputes, ownership claims, licensing and transfer, financial negotiations, and helps in the enforcement of rights. So, and you can remember this like this, or just we'll go with directly the diagram. You can observe here filing the application. You have to write this flowchart in the exam for the process of copyright registration because they will mention that along with the flowchart only you have to explain. Filing an application with the fee. Then I said they will issue a diary number. Then it is a waiting period of 30 days. Objection is filed. If the objection filed is yes, then we will send the letter to the applicant that there is an objection. Then the reply from the applicant. Then there will be a hearing from the registrator. Then the decision of the registrator. If it is satisfied, then the application will be accepted. If it is not satisfied, it is rejected and a letter will send to the applicant as it is rejected. Now, if the objection filed is no, then it is scrutinized by the examiner. That application which is accepted. Then disparity. Here, if it is yes, then there will be a letter sent to the applicant, a reply from the applicant, then decision of the registrator and the registration is approved. If the registration is approved, sending the extracts of from the registrator to the applicant. If not, it gets rejected. So it is also do note that copyright registration is not compulsory. It provides a strong legal evidence. So the registration process ensures transparency, objection handling, and the legal clarity, making it beneficial for the copyright holders. Next, we'll move on to the judicial powers of the registrator of copyrights. So, registrator of copyrights has powers similar to the civil code. So, the powers are exercised while trying a suit under the Code of Civil Procedure. Powers of the registrator: summoning and attendance, power of to summon a person and examine an oath. Then discovery and production of documents, evidence of an affidavit, issuing the commission's requisition of public records, prescribed matters. Then time and the objection process. So it is usually takes 2 to 3 months for the registration. After filing, it is a mandatory period of 30 days. Then during that period, any time the objection may rise. So a person can raise objection to the claim and he provides a hearing to both the parties. Registrator provides, then it may decide in favor or in against of the author. Next is examination and the final grant. Any objection that is cleared, then queries or doubts are raised. Applicant will be given 45 days to respond. So after the clearance, it is granted. Copyright symbol. It is not mandatory to use the copyright symbol. Using the symbol makes it easier to prove the infringement in the court of law. So the symbol here can observe is copyright is represented C with a circle, or you can write the word as copyright or COPR. So year of creation and publication, the compilations or the derivative works, the year of first publication should be mentioned. Year may be omitted for some pictorial works or graphical works like that. Name of the copyright owner with a full name. Sound recordings use the symbol P with a circle instead of C. Validity of copyright, it is around 60 years. Starting point of validity, it is literary, dramatic, or music or artistic till the death of the author. It is calculated 60 years from the year of death. Cinema or sound recordings, that is also same from the date of publication. Then posthumous publications here 60 years from the date of publication. Government work also from the 60 years. Then works of the international organization 60 years from the date of publication. Copyright profile in India. So we are having a 5-year comparative study shows a gradual increase in the copyright application. The highest number of application was in 2019 to 20, having 21,905. Maximum number of applications were examined in 2017 to 18, that is 34,388. Examination numbers declined to this as the year increased. So copyright registration peak was in 2017-18. Copyright work and the word publish. A work is considered published only when it is placed in a public domain without restriction. So, distribution with a non disclosure conditions does not amount to the publication. Removing the restriction or posting on the internet makes the work published. Both the published and the unpublished works are eligible for the registration. Transfer of the copyrights to a publisher. So, author often transfers the copyrights to the publisher for lump sum payment, royalties, combination of both. So, unconditional transfer may have negative consequences. So, publisher may restrict posting on the institution websites, revision of work, or print the limited copies, avoid online distribution. Author should be careful while signing the agreements. Next, copyright in the digital era. So it is fully dependent, and there will be authors can directly publish their work, and authors are already under a publishing contract, cannot bypass publishers. Termination of transfer. So Copyright Act provides a termination of transfer provision. So certain agreements can be terminated after 35 years. Rights applies even if not mentioned in agreement. So authors are strongly advised to apply the caution before signing the agreement. Author and the word adaptation. Adaptation means creation of a new work based on the existing work. So this includes converting a dramatic work into non-dramatic form, changing the literary into drama, rearrangement of the literary into drama, pictorial depiction of literary to drama, like this, making a cinematic film from the literary or music work. That is, copyright and the work Indian work. This means literary, dramatic, or the music work if the author is an Indian citizen or the work was published in India. In case it is unpublished, then the author was an Indian citizen at that time of creation. Joint authorship or the work of joint authorship. It refers to created by two or more authors. Collaborative work, and it is not distinct or not separable from others. The work is treated as single unified creation. Copyright society. So this is important. This is asked in I guess model question paper to the laws and regulation roles and functions of the copyright board. So here authors and the copyright owners often cannot track the usage and royalties of the infringement. So address this, there is a copyright society are formed in the section 33 of the Copyright Act 1957. A copyright society is registered collective administration society. Function of this is to tracking the rights and infringement, issuing the license, collecting the license fees, distributing the royalties, like that. Then formal formations and the validity is 7 or more copyright holders will form a society, and the term of registration is 5 years. So the registered copyright sections societies in India are uh, SCRIP, that is Society for Copyright Regulation of India, producers for film and television, for cinematography and the television films, IPRSL for music work, PPL for sound recordings. Coming to Copyright Board, it is a statutory regulatory board performing the judicial functions under the Act. So this board consists of chairman and 2 to 14 members. The chairman is the level of High Court judge. Powers is hearing appeals against the orders of the registrator of copyrights, rectification of entries, adjudications of disputes, granting copyright licenses, granting copyright license for translations after 7 years, then deciding the disputes, then fixing the royalty rates, like this. Next comes Copyright Enforcement Advisory Council. So this was set up in the government in 1991. So why? To review the enforcement of the act, to advise the government on improving the enforcement measures. The term is 3 years, and it is reconstituted periodically after the completion of its term. So international copyright agreements, conventions, and the treaties is the protection is territorial in nature, and it is not automatically protected worldwide. So, to protect the Indian work abroad, authors must apply separately and seek through the international conventions if the countries are members. So, some of the international conventions in which India is a member is Berne Convention, Universal Convention, Copyright Convention, Rome Convention. Like the TRIPS agreement, it is a trade-related agreement aspects of the intellectual property rights agreement that is in 1995. In India, copyrights of the foreign authors are protected by the international copyright orders. Coming to the interesting copyright laws, some of the special laws you can observe the Happy Birthday to You case law. It was considered the most recognized song. So, melody originated from the Good Morning to All melody, and in the 1935, copyright registered for the piano setting only. And then the Warner collected the royalties after 1999. Court ruling only the melody was protected, not the lyrics. So what was the result? The song was declared public domain, royalties refunded to users. Then Amitabh Bachchan's copyright over the father's work. So here, uh, his father died in the 2003. As per the act, the rights last for the author's lifetime. He was a poet, so that it lasts for the author's lifetime plus the 60 years. So copyright over his work will expire in 2063. After 2063, this work will enter to the public domain. So this was all about the copyrights and the related rights module for part 1 video. I hope you have understood everything. Thank you for watching. Do like, share and subscribe to Exam Ignite YouTube channel. See you in the next video.